Thanks, Tim. So before launching into talking about the LLLT program, which is what we affectionately call it, the Limited License Legal Technician Program, I think it's helpful to talk first about the context for the legal profession and the issues that we're facing, and the context, therefore, in which the LLLT idea developed. So for just a minute, I'm going to take us to the bigger picture of the profession, and if you're taking notes, I would encourage you to put 3 arrows down. The first arrow would be an arrow pointing down, because what we know as a profession is that we are facing a shortage of lawyers coming in the near future. The silver tsunami is here, and the baby boomers are starting to transition out of the profession. Our research shows us that fully 50% of our members in the Washington State Bar will transition out of the profession in the next 5 to 15 years. We're 38,000 members, and we know that 50% of those members will transition out. So that's the back end. At the front end, we know they're not coming to law school in the same numbers, right? Law school applications are down 50% across the nation, and 2 years ago, 80% of law schools missed their entering class sizes. The National Conference of Bar Examiners just put out some data that shows you that almost every law school in the country has reduced their entering class size in the last 2 years. So we're losing them on the back end, they're not coming in the front end. The second arrow I'd have you write down is an arrow pointing up. And Ron talked about this, the increasing public demand. Our Supreme Court commissioned a civil legal needs study in 2003, and it quantified the unmet need in Washington. And our numbers aren't any different from anyone across the nation. 80% of low and moderate income clients go without the representation that they need in civil matters. And I think it's always really important to stop and drill down on that moderate income number. That's a family of 4 making $94,000 a year. So when I'm not in Chicago, I say, that's your Boeing family, right? $94,000 a year, we are not talking about the working poor, and fully 80% are facing civil matters without representation. The World Justice Project shows us that 50% of middle-income folks, that's us, are going without representation in civil matters. And then out of the University of Illinois, Rebecca Sandifer has just done a bunch of research to show us there's a whole nother latent market of people. These are people that don't even know they have a legal problem. Or if they have a legal problem, they just don't even think about coming to a lawyer, right? They're going to their union leader, they're going to their minister, they're going to a family member. So we've got huge unmet need. The last arrow I'd have you write down is an arrow pointing to the right. Because consumers are just going other places, right? They've got this Home Depot mentality. I can do it myself. They're going to places like LegalZoom. Over 3 million customers for LegalZoom, right? They're going to these other places online or just not even coming to us, so the consumers aren't coming. So this is the context within which we as a profession have to navigate and figure out how we're going to serve the public. So as regulators, we've been thinking about this, writing about this, talking about this for the last several years, because what we know is that in the future, we will not be educating and regulating lawyers. We will be educating for and regulating a legal services delivery market with lots of different types of legal professionals. And yes, I know that's a picture of doctors, and I did that deliberately because this is what happened to the medical profession 40 years ago. Right? Congress comes in, says to the medical profession, you are not serving the public. And this is when we begin to see the advent of other types of medical professionals, right? Nurse practitioners, physician's assistants. There are probably people in this room that remember a time when only a doctor could draw your blood. If a doctor walked into your patient room today, you would either run for the door or you would say, bring me the phlebotomist, bring me the nurse. It's not because the doctor doesn't know how to draw blood. It's just not the best use of the doctor's skills or the doctor's time. So just like every medical problem doesn't require a doctor, not every legal problem needs a lawyer. And that's really where the development of the LLLT idea comes from. And as you know, in Washington State, we have the first independently licensed paraprofessional in the country. And I'll just get it out right here at the beginning. We do not consider LLLTs non-lawyers. They have a license to practice law from the state Supreme Court, just like I do. It's just in a narrower scope, and I'll take you through that in a minute. So the development of the rule actually went over 10 years, so I don't want you to think this came about pretty quickly. And I'm going to be honest with you. The Bar Association, and I mean small b, meaning the bar, and capital B, the organization, fought this idea. We fought it till the end. And the Supreme Court board that was charged with developing this idea was really operating on two tracks. And one was access to justice. How can we create a new way to enhance access to the justice system, always keeping in mind that our priority is to serve and protect the public? And the second track, of course, was consumer protection. That is, we needed to ensure that whatever was developed was somebody who was qualified and, importantly, regulated, so that we were serving, and I really want to emphasize, protecting the public. So this was a 10-year venture, and then they recommended this rule, Admission and Practice Rule 28, which creates the limited license legal technician program. And in June of 2012, our Supreme Court adopts APR 28. And I'm going to just read to you here from the order. It was a 15-page order that accompanied adoption of the rule. That's pretty unusual. And I'm just going to read this quote from the Chief Justice's order, because I think she captured it really well, where she says, "We have a duty to ensure the public can access affordable legal and law-related services, and that they are not left to fall prey to the perils of the unregulated marketplace." Right? Because people, when they're going to these charlatans who are offering legal services and they're not qualified and regulated, they're just going because they want to get help. And our point was, let's put some other actors into that market who are qualified and they are regulated. So when we sat down with the chief and we asked her, how soon do you want this program up and running? And she said, sooner would be better than later. So the LLLT board was running pretty fast. They had to create this whole program out of whole cloth. And the first order of business, of course, was to decide what was the first practice area that the LLLTs would be licensed in. And just to emphasize that, LLLTs are only licensed in certain areas, but the vision is that they can be licensed in multiple areas. So the first area that was chosen was family law, and that was what the LLLT board recommended to the Supreme Court. If you read the 15-page order that accompanied adoption of the rule, the Supreme Court was tipping their hand pretty clearly what they thought the first practice area should be, and I'm sure it's true here. Lots of pro se folks working their way through the family law system. So let me take you quickly through the nuts and bolts of a legal technician. I'll just take you through these, and I'm going to drill down on a couple of these. So they must be 18 years of age. They must have a minimum of an associate level degree, so from a community college. They'll have to meet certain education, exam, and experience requirements. They have to show proof of financial responsibility. So you may know that Oregon is the only state in the United States that requires lawyers to have malpractice insurance. We actually require the LLLTs to have malpractice insurance. They will have to do mandatory continuing legal education, and they also have their own set of RPC. So in Washington State, we actually now have 3 sets of RPC. We have the lawyer RPC, we have the LLLT RPC, and then we have another limited license that we've had for about 30 years, the limited practice officers, and they also have a set of RPC. So 3 sets of RPC in Washington State. LLLTs are held to the same standard as lawyers, and they are given the privilege. And then they are, of course, subject to discipline. So you can see it's sort of creating a whole another regulatory system that mirrors the lawyer system. So let me take you through some of the requirements of how to become a LLLT. So as I mentioned, they have to have an associate level degree. In Washington State, that is 90 credits at a community college. Of those 90 credits, 45 of the credits are defined by the regulators. So they're in the rule, what these courses are that the LLLTs have to take. And it's sort of like a paralegal program, but it's a little more enhanced. So I'm happy at the reception to talk to people if they're curious about what those 45 credits are. So once they finish the core education, then they have to do what we call a practice area education. So in each area that they want to be licensed, each practice area, they have to do a set of educational requirements. Now the rule requires that that practice area education be developed by an ABA-approved law school. And so our law schools came together and said, let us develop that curriculum for you together. And so they all came together and determined that they thought it needed 15 credits. Now, our vision had been that we would take that curriculum, we call it kind of curriculum in a box, and we would hand it back to the community colleges to teach, either with a community college instructor, a law professor, or a practitioner. But we came to the end of it, and one of the law schools said, let us teach it. And we thought that was great. Now remember, go back to that first arrow that was pointing down, right? They're losing customers, right? Because the JD applicants aren't coming. And so they said, let us teach these courses. And so that's the University of Washington, and Gonzaga is also helping teach the courses. So all of the courses are cited at the University of Washington. They are streamed statewide because we wanted to assure accessibility. Washington gets a little rural when you get east of Seattle. And every class is twin taught by a law professor and a practitioner. So imagine when we were in law school, if you would have been getting doctrine at the same time that somebody was telling you, and here's what it's going to look like on the ground. So 15 credits taken at the law school, 5 credits are in basic family law, and then the next 10 credits really drill down into what the scope of their authority is, because remember, they have a limited scope. They can't do everything that we can do in family law, and that takes 15 credits. So for the examination, they have 3 exams. They take 1 exam at the end of the core education, and this is one of the national paralegal exams because we realized it didn't make sense to recreate that wheel. So they taken and I'm sorry, I can't remember which one, but the national paralegal exam. They have to take an ethics exam, just like we do. And then what they do is they take a practice area exam, and it mirrors the uniform bar exam. So it has a multiple choice component, it has an essay component, and then it has a closed universe practicum that they have to do. The core exam and the ethics exam you take once, and once you pass it, you don't have to take it again. But the practice area exam you'll have to take for each area that you want to be licensed in. So of course right now we only have a practice exam for family law because that's the only authorized area right now. So that's the examination. And then on top of all of it, they have to do 3,000 hours under the supervision of a licensed attorney before they can get their license. So again, imagine when you were in law school, and some of you probably did work in a law firm, having that context of what it's like to actually be in the law firm or in the legal field working while you're being taught how it all works. Now, one of the things that I thought the board did was a great recommendation, which is they can be doing the 3,000 hours before they start the education, while they're doing the education, and then if you have some hours to finish up after you've passed all the exams, you can do that, because otherwise the pathway would have been so long, right? You have to do the community college, and then you have to do the law school piece, and then you're still facing the 3,000 hours, which is the equivalent of about 18 months of full-time work. So those are the 3 main requirements for getting a license. And then you can just see the license requirements are similar to us, right? They have to do a trust account declaration, they have a license fee. As I mentioned, they have to have malpractice insurance, and then they have to have public information so so public can find them, contact information. So everybody always wants to know how many are there? There are 10 licensed LLLTs right now. So remember, the chief said sooner's better than later. So actually what we did, and you might have seen that on one of the other slides, in the beginning, there's actually a waiver right now. So if you've been a paralegal for 10 years or more working under the supervision of a lawyer, and you are certified by one of the national paralegal associations, you can skip the core education piece and go straight to the practice area education, and that was a great way to get some folks into the pipeline. So there's 10 that are licensed now, but I will tell you that we have a couple hundred coming up in the community colleges. So we envisioned that they would probably operate in 3 different models, and they're actually doing all 3, and actually a 4th that we hadn't envisioned. So remember, they can go out on their own, they can be a standalone, firm. They can work with a lawyer, and we've changed our lawyer RPC to allow lawyers and LLLTs to share fees, or co-own, the firm. The LLLT can only own up to 49% of the firm. They can't have a majority ownership of the firm, and they cannot control or dictate any of the lawyer's decisions. We're seeing them actually being hired by volunteer legal programs, right? So that makes limited federal and state dollars go further. And then one we never thought of, which is happening in Central Washington, is the trial court judges have approached her and asked her to come be in the courtroom so that she can help folks as they come in, the pro se folks. So those were the business models that we envisioned. And as I said, they're working in all three models and the one we didn't envision. So I'm going to leave you, because I have to stop now, with one image. And this goes back to the 3 arrows that I talked about. And that is that the consumer is leaving us. And I want you to notice it's not a shark. Because really what the fish represents is the consumer, and that's us, the lawyers, on the hook, right? And they were so hungry for us, right? They were always chasing after us. But what's happening is we're getting less, they're getting bigger, and they're just swimming on by. They're not even looking at us. And we need to figure out how we're going to get back in the game and become relevant to the consumer and stay relevant to the consumer, because they're just going to leave us. So, thanks.